Welcome to Straightforward Conversation with Garry Hunter. I'm Garry Hunter. My guest tonight is Karen Harvey, Magistrate of the Athens County Court of Common Pleas, Domestic Relations Division. Tonight we're going to be continuing a conversation that we had on a previous evening about Domestic Relations Court in Athens County, its operation and procedures. Karen, we left last discussion on the topic of child custody, and there were a number of other issues that I wanted to get into, so we've asked you back this evening for the continuation of that discussion. I'd like to start out tonight with the issue of child custody and jurisdiction of the Athens County Common Pleas Court after the divorce proceeding is over and you've made a child custody award. Do you have continuing jurisdiction? And if you do, what happens where, say, one parent moves out of the state or both parents move out of the state?
Okay, yes, we do have. There's a concept in the law that you like to have legal issues settled once and for all, and so after the court has made a decision, that's it. If you don't take it up to an appellate court, then that's it once and for all. There are 3 issues, though, where it has recognized that that's not a viable concept, and they are the issues of custody and visitation of children, of the support, child support, and spousal support, that the court can revisit those issues if an appropriate motion is filed with the court. Now, you also face the situation that if a parent doesn't get from the court what they want the first time, that 2 weeks later they come in and file a motion and say, let's do this all over again. So there are some legal barriers, I guess you might call them, that are written into the law in Ohio that before the court can relitigate the issues of custody, not visitation so much, but child support, you have to come to court and demonstrate that there has been a significant change of circumstances in the life of the child or of the residential parent. And they limit that to the residential parent so that the non-residential parent can't go out and make a significant change in their life and thereby create the change of circumstance that lets them come right back to court. That also helps to lend some stability to a child, to not have to live under the possibility that, you know, next year I might not go to school here, or to try and set it up so that until there's been that significant change, you don't
Under our unique
redress these.
Form of government, every state is an individual sovereign.
Yes.
So what happens where, if I'm involved in a divorce proceeding and I move to California and my wife moves to Florida and we don't agree anymore on child custody or some of these other issues are permissible as continuing jurisdiction, where do we fight that battle? Ohio, California, Florida, meet in the middle, the Mississippi River, or what?
That is such a problem that there is now uniform legislation in all 50 states, that each state has adopted what's called the Uniform Child Custody Jurisdiction Act, and it sets forth a series of criteria that a court must address when you have cross-state situations with children. For instance, theoretically, if parties got a divorce in Athens County and had children, the Athens County Court retains jurisdiction over the child-related issues until the children are 18 or have graduated from high school, whichever happens last. But if the custodial parent, and we're a very mobile society. People move for very legitimate reasons, to better their professional or to get a job in the first place, to go to school, to be nearer to extended family members. If you move to another state and have had the children in another state for at least 6 months, that's one of the criteria. Then that state becomes the home state of the child, and that can divest Athens County of its ability to go ahead and it's kind of a complex idea. It doesn't divest it of the jurisdiction. It divests Athens County of its ability to exercise that jurisdiction. And then what the courts are supposed to do is you're supposed to pick up the telephone. And if you have a court proceeding in California and a court proceeding here, The judges are supposed to have a conversation, follow it up and memorialize it with a letter, and agree as to which court is the appropriate forum for hearing that, so you don't get this tendency, well, I lost in Ohio, I'm going to move to California and try over again.
If we assume that jurisdiction is now appropriate in Florida, what law do we apply, Ohio or Florida?
If the children are down there, then you're going, under the proceeding, you're going to apply the law of the state that has the appropriate, that is the appropriate forum to go ahead and
So there could be some forum shopping then. If you don't really like the result in Ohio, go to a state that may have a little bit different philosophy, establish your jurisdiction.
Very definitely.
Try filing.
That's a minimum, because most parties cannot afford to move a great distance for that reason only, but it is not unheard of, yes.
What do you do about the non-custodial parent who, let's say, he or she doesn't move out of Athens County, but moves to Toledo, Ohio, some 4.5 hours away? How do you deal with the issue of who pays transportation costs for the child? What's appropriate?
Again, no set formula. If you have parties where their incomes are relatively equal, or their ability to provide transportation is relatively equal, then you're going to set it up on a shared transportation way. If you have one party that is far more capable of providing that transportation, they may bear a bigger part of the burden. There are also provisions within the child support laws to deviate from that statutory child support schedule in the state of Ohio because of extraordinary costs of visitation. For instance, if one of the parties moves to Alaska and you have to fly those children, 3 times a year to Alaska, you may not be able to pay the full amount, the non-residential parent, the full amount of that child support that's ordered, and still be able to have that relationship with your children. So the law has deemed that the relationship takes precedence in some instances over the money. So there's no pat answer to it, but there's different ways that the court can address that problem. It's a common problem. Yes.
How do you deal with I think we all know that sometimes the custodial parent over an extended period of time will, I hate to use the word brainwash, but I guess it's probably the most appropriate phrase, brainwash the child against utilizing the visitation schedule that is available to him or her. And the child says, I don't want to go. And all they have to say is, I really don't want to go. And the custodial parent says, you can't go. You can't pick him up, or you can't pick him or up tonight because she doesn't want to go. It's a mental drain on her or whatever. How do you force the child to go in those situations?
Well,
or how do you decide if it's appropriate to force the child to go?
All right, the first thing is somebody has to bring this to the attention of the court. The most common way that those situations come to court is that the parent who isn't getting visitation files a contempt of court action alleging that the other party is in violation of the court order. There is some case law, and there is a case that I have cited a number of times in the 4th District, that there comes a time in a child's life when they reach someplace in the teenage years. And I kind of have, an example I've used is, you've got a 16-year-old boy who plays, tackle on the high school football team. Mother is the custodial parent. There comes a point in time at which mom can't pick that child up and carry him out to the car and say, you are going on visitation. On the other hand, parents have other compliance measures available to them. We use them every day in getting our children to follow regular rules. And so a lot of times, if it comes to court, you're looking at the reasons for why that child, if the child just doesn't want to go because they'd rather spend Saturday night, overnight, every Saturday night with an overnight with their friends than ever go visit the other parent, then maybe you say, sorry.
You have to go. But
yeah, your custodial parent may face a contempt of court with a severe penalty if you don't, on a reasonable basis. And sure, I can see that if it's the junior-senior prom night, you may be a little upset if you have to drive to Lancaster and spend that night. It probably isn't going to be a real pleasant weekend for the family up in Lancaster if you're made to go. But, there's got to be some give and take there. But for the most part, a custodial parent has a responsibility to try and get that child there.
And
Now,
you will make that clear to them that they have a
abs-
responsibility.
absolutely. The other hand, sometimes it's the custodial parent and not the child who
Right.
doesn't want that relationship to take place. So
I think in many cases it's the custodial parent and not the child.
well, yes, I mean, in many cases it is. I've also seen times, though, when children get very, and there's a certain age, especially high school kids, or children that are involved in sports programs or baton twirling and really get caught up in it, who really resent having to up and have that schedule disrupted.
Well, stay tuned. Karen, I'll be back after this commercial break. When we come back, we're going to discuss domestic violence and how the Domestic Relations Court deals with that issue. Welcome back to Straightforward Conversation. Karen, before the break, I was about to ask you about domestic violence, which is a large national problem. How is it dealt with in the arena of divorce proceedings, and what laws are, if any, are available for you to utilize in dealing with that issue at the domestic relations level?
Okay, there's a couple of ways that it can come up as an issue within the context of a divorce. And then certainly in terms of grounds for divorce, domestic violence can be extreme cruelty that would give someone the grounds for obtaining a divorce. But there is also a separate proceeding in domestic violence that you can file in a domestic relations court and ask the domestic relations court to give you what's known as a civil protection order. Essentially, a victim of domestic violence has a couple of choices. One is to file criminal charges in a court that has criminal jurisdiction.
Such as, where would that be filed?
Well, that's usually, it starts out in the Athens County Municipal Court. Of course, if it rises to the level of a felony, it may end up over in the Court of Common Pleas. But the first step would be in the Athens City Prosecuting Attorney's Office for filing of domestic violence criminal charges in the Athens County Municipal Court. But a victim also has the right to come to the Domestic Relations Court and ask that that court just issue a civil protection order protecting them from further abuse.
And this is without actually filing a divorce proceeding?
You don't have to file a divorce proceeding. You don't have to file criminal proceedings. It's a very different standard, because if you go to court on a criminal case, the standard is beyond a reasonable doubt. If you come into the Domestic Relations Court and you want a civil protection order, the standard is preponderance of the evidence. Is it more likely than not that this domestic violence has occurred? We're not talking about guilt or innocence. We're talking merely about, if they have demonstrated that there has been an act of domestic violence, then you issue a civil protection order. If you violate that civil protection order, you may then be facing a criminal charge, or you can come back to our court on a contempt charge.
Do children have to be involved to file this civil domestic violence order?
We frequently have children that are involved in it, not necessarily as the victims of the domestic violence, but who are affected by the fact that the domestic violence maybe have effectively alienated parents, and then somebody has to decide which of these parents is going to be the appropriate custodial parent, and whether or not there should even be visitation with the person who has committed the act of domestic violence.
As a prosecutor here in Athens County, I'm aware that one of the major problems with domestic violence is the syndrome of the victim, the circular syndrome of the victim going back to the abuser and dropping charges, wanting to drop charges. How do you deal with that at the civil level? I know we have a problem with it at the criminal level.
Tolerantly. And I say that because there is a syndrome there. There are a lot of pressures, I think, on a victim, particularly if there are children involved, to return to that party. And if you say, all right, you filed and dismissed once, you're not coming back into court again, the next time down the road, they may desperately need that protection order. There is no penalty. We have people who file several before we actually get them in, who file several, and they are dismissed. They don't show up for hearings. But if a victim of domestic violence files a petition and doesn't show up for hearing, perhaps they've been intimidated and don't show up, so you don't know why it is that they don't show up for that hearing. And if, in fact, it is intimidation that's keeping them from appearing, then perhaps the next time they'll work through the battered women's program or something that will actually get them into court and get that order.
I know in the criminal arena, we talked earlier and you mentioned that the standard is much higher in the criminal arena than it is in the civil. But in the criminal arena, we regard once the domestic violence charge has been filed as a charge that belongs to the state, and that the victim is merely a witness on behalf of the state. So the actual dismissal belongs to the state, not to the victim. And we will not allow a victim to dismiss the charge until they have at least gone and received counseling from the local battered individual's shelter. Do you mimic that process over in domestic violence, or is it even appropriate over there in domestic violence?
No, it's very different. I don't know but what it might not be appropriate, but there's no mechanism by which the court can order the victim or person who claims to receive counseling, and certainly they're not to be put under a protection order. The law is very clear that an individual files a petition in domestic violence and comes into court, and the alleged perpetrator of the domestic violence can't say, well, I want this to be a two-way thing, and then you have to say, fine, you file your petition in domestic violence, you come in and demonstrate to the court that there has been an act of abuse, and we'll look at it separately, but you don't just issue mutual restraining orders. Now, parties can come into court and agree consensually to mutual restraining orders, but you don't find that happening very often.
Almost never is my experience. Is there a mechanism, at least in Athens County, for an open dialogue among various agencies that deal with domestic violence, and a uniform system of communication in Athens County on domestic violence issues?
There wasn't until about a year and a half ago when there was a grant given to Athens County to develop a model protocol for how the community was going to handle domestic violence. And so there was the establishment of what's called the Domestic Violence Protocol Task Force, and there's about 15 of us. It's Judge Bennett from the municipal court, George McCarthy from the city prosecutor's office, various members of the county prosecutor's office has been present. Usually the Athens chief of police is there, somebody from OU security, there's always a representative of the Athens County Sheriff's Department, someone from my sister's place, Athens County Children's Services, the 317 board.
It's a very large group.
So, yes, and it's a very comprehensive group, and we sit down. We have developed a brochure that will be ready shortly that law enforcement officials can hand out to all. In fact, there's been an earlier one, but it's being redone so that when law enforcement officials respond to a domestic violence incident, they have a brochure to hand to the victim saying, here are your options, and it could be some of the things that we have talked about here.
Is there a training program for law enforcement officials?
Yes, there has been some very good. There have been two of them done. One, they brought in a national trainer from, I think, San Diego to train, and there was a very good turnout from local law enforcement people. We have also in draft form now a uniform preferred arrest policy, so that, and the theory is that we're going to get all the law enforcement agencies, all the village marshals, OU security, Hocking Tech security, to all adopt that same policy so that they're all working under, and that's part of the new statute that went into effect in December, mandating that every law enforcement agency have a written arrest policy. And we'd like to see that uniform in the county. And it's also been just sitting down and each of us saying, here's our problems, and learning that we can't each operate in a separate little vacuum and not realizing it. You know, if the Domestic Relations Court issues a civil protection order, then it's got to be written in such a way that a village marshal responding out there can read it and understand it, and that it gets to all the proper law enforcement agencies to go into their indexes, and that whole process. I've even gotten to the point where the ones that come out of the Domestic Relations Court, we attach an orange cover sheet to it so that when it gets to the city police or the sheriff's department, they're not going to miss it. And just little things like that to try and streamline the process.
Well, stay tuned. Karen and I will return after this commercial break. When we come back, I want to talk about a new feasibility study that is going on in the Athens County domestic relations court. Welcome back to Straightforward Conversation. Karen, before the break, I was about to ask you about a new program that you had mentioned to me before the program started. As I understand, Athens County has been selected for a new statewide study. Could you tell us something about that program and what it is?
Sometime this fall, the Ohio Supreme Court decided that it was time to take a major look at how the courts in Ohio are handling family problems. And that's family problems in a very broad context. It includes adoptions in probate court, maybe guardianships there. It includes any number of aspects of the juvenile court, unruly and delinquent children, dependency and neglect and abuse cases in juvenile court. It includes everything really that comes before the domestic relations court. And it also includes such things as domestic violence that is occurring in municipal courts. And so the Supreme Court hired the National Council for Juvenile Justice, which is an agency that I think it's an arm of the National Council of Family and Conciliation Court, something like that. That they operate out of Pittsburgh, to come in and do a major study in the state of Ohio to take a look at how the courts are dealing with family problems and some suggestion ways. Either say, hey, you're doing a great job, or you need to just fine-tune it a bit, or you need a major structural changes within your court system to better handle that. The first year supposedly is going to be to take a look at what we are actually doing, and to do that they selected 10 counties, ranging from Morgan County, which is the smallest, to Cuyahoga County, which is not that Morgan County is the smallest, it's the smallest selected. Right. And each of those 10 counties has a different configuration for their court system. And there'll be a study team that comes in to each of these 10 counties to gather statistics, to talk to us about what we're doing, to watch what we're doing, to ask us, what do we think we're doing well? What do we think we could do better? How would we change it? What laws? And so David Warren, who is the part-time magistrate in the Athens County Juvenile Court, and I were in Columbus last week for the first information session to listen to what it is that they have in mind, what kinds of questions they'll be asking, what kind of information they need from us. And supposedly we'll be having a team coming into Athens County within the next couple of months to start. And it's kind of exciting to be a part of a process like that. I certainly feel more comfortable, even though it's going to be time-consuming for some of us, being a part of it, than to know that it's going on and not be a part of it. Yes.
Well, Karen, this has been a very interesting discussion. I think we could go on for hours. I want to kind of wind up tonight's conversation with a loaded question and then turn around and give you only about 2 minutes to answer it. The question I have for you is one that is a personal question of mine, and that is divorce or dissolution really too easy now in Ohio and other states, and should society as a general policy make it more difficult for parties to get a divorce or a dissolution so that they'll work at the marital relationship and work harder at it to make it work, at least until the children are adults?
You're right, that's a loaded question, but it's becoming, I think in the last 3 or 4 weeks, I have seen articles in the New York Times on that very subject, in the Wall Street Journal on that very subject, it's a current topic that is being discussed, and the reason for the discussion is as the divorce rate has continued to escalate, there are more and more studies about the impact of the termination of a marriage on children. And everything I have read is nobody seems to care if spouses without children can come into court and dissolve the marriage. That's fine. Leave the laws in place. Do we need to assess various family situations? Certainly, I have seen situations where, especially if there's domestic violence present or substance abuse, that maybe I won't say maybe, that terminating the marriage and getting the children out of the situation is undoubtedly the best. I have also seen particularly dissolutions where I see parties walk in perfectly amicable and say, well, just 3 kids And in 15 minutes, in fact, you can get a dissolution with children involved in lesser time than you can get married in the first place.
The old common expression, we fell out of love.
Yes.
Is that a reason for getting a divorce?
And so in Ohio, yes, that is a reason
Should it
for
be a
getting
reason?
divorced. Should it get it? I don't know. I honestly do not know. And I think the reason I have a hard time answering that is because it's got a very personal aspect to it as to how you yourself feel about the institution of marriage. You know, I've been married for 35 years to the same person. I'm sure I look at it differently than a lot of other people, particularly younger people in our society do. But I do think whatever the way of resolving that, we need to be paying greater attention to the impact that divorce has on the children that are involved.
Well, thank you very much, Karen. This has been Straightforward Conversation with Garry Hunter, and good evening.